Ladies and gentlemen, welcome to Panel 2, First Hand. Please welcome President of the William and Flora Hewlett Foundation, Mr. Larry Kramer.
Thank you. It's really an honor and a privilege to be here. I was asked just to say a few words to introduce the next panel. And I think I would start by saying something that probably we all know, which is the court is a fairly powerful institution. Now, of course, it wasn't always so, although one of the signs of how powerful it is that you really do see in any presidential election people saying it matters who you vote for, you should vote for X rather than Y because they're going to pick the next Supreme Court justices. But if you think about why that really is so, the court decides about 80 cases a year. And about 75 of them need to be decided, but they're not the reason the court is such a powerful institution, and they're not the reason people say that about who you should vote for in the presidential election. In any given term, there's typically 5 or 6 cases that are really the reason why we care about the court. And those are the cases that have truly significant impact on our politics, on our society, on our government. They're also, though, typically cases, the reason they're so hard and part of the reason that makes them so important is the law runs out before you get to the decision. So how do we justify giving so much power to what amounts to a kind of monarchical institution in cases like that? And it's not actually so easy to do if you think about it. But one of the ways we do it is by who we appoint, who we give that kind of power to. So we look ideally for people who have experience in politics, who have been in a position where they've had to make some of these really hard decisions with responsibility for the consequences of those decisions. And then, in the ideal world, we remove them from politics in the way we structure the court, and they have a kind of wisdom that they can bring to bear on those cases when the law runs out. So that last little bit, when the legal justifications might take you one way or might take you another, they can bring that to bear in the decision and exercise judgment, which is, of course, why we call them judges. So in those 5 or 6 cases every term, it's that kind of experience that matters. And the truth is, if you look across American history, we used to routinely appoint justices who had that kind of experience. We had justices who had been governors or senators or cabinet officials, people who had really been in the heat of politics, in important political decisions, sometimes at the state level, sometimes at the federal level, with real responsibility for the consequences of what they did. And if you think about it, Justice O'Connor was really the last justice of that ilk. And you see it reflected in her decision-making. Part of the reason, by the way, is it's because the court has become so powerful. It becomes really difficult to get anybody through the appointments process we have now if they've ever actually done anything in life. But at least when she was appointed, and for all sorts of reasons, we heard on the first panel, they went to somebody who was quite unconventional, but somebody whose important experience for the court was not her experience as a state court judge, but as a state court, as a state legislator, as the leader of her party in the state, as someone who had had that kind of experience in politics. So what happens when the law runs out is you can see that reflected in Justice O'Connor's opinions. And you could see it not just in what she decided, but in how she decided it. Of course, no one gets to see how a justice decides their cases better than her law clerks. Not even her fellow justices got to see as close or as much of what made the justice who she was as a justice. Clerking is a really unique job. It's not really a job. It's closer to a discipleship than it is to a regular job. You work long hours, and I can tell you the O'Connor clerks worked longer hours than most of us. You have incredibly close contact with this person. You spend your time thinking not about how you can influence them, because very few of us had the kind of arrogance, particularly at the age of 26, to want to push the justice in a different direction than he or she wanted to go, but really trying to understand what it is that the justice needs or wants or is trying to do, and to fulfill those needs, to provide the research, to provide the thinking, to provide the kind of argumentation that helps the justice shape her views. So who better to give us a sense of what it was that made Justice O'Connor the justice that she was? Who better than those, particularly in those key cases and important cases, who did the work with her? And so with that, let me bring on the next panel. I think you'll be really interested to hear some of the firsthand experiences of the people who had the opportunity to work as closely with Justice O'Connor as only her clerks ever did.
Ladies and gentlemen, welcome to our panel about the firsthand experience of clerking with Justice O'Connor. We are honored to have three extraordinarily distinguished scholars who also clerked with Justice O'Connor during her early years on the court, during the 84, 85, and 89 terms. So I think we should begin by asking, what was it like to clerk with her as she was still adjusting to the extraordinary role of being the first woman on the Supreme Court? And Chancellor, we'll begin with you.
Sure. She was the most famous woman in the United States at the time. She drove a Honda Civic herself. She was incredibly demanding and incredibly supportive as well. And what a blessing that was to have early in your life, to have a boss who insisted of the best of you, but also knew you had a family. So I'd say it was exhausting and exhilarating at the same time.
Marcy Hamilton, Professor Hamilton, you talked about how she taught you to be a professional. Tell us about that.
So, the thing about clerking for Justice O'Connor is that you learn how to be incredibly honest while you're smiling. And you learn not to put in writing things that you don't want to read again. So I'll never forget in the abortion cases, I was very, very unhappy with Justice Scalia's treatment of the justice, and I really wrote it up. And I wrote a response that we nailed him. I mean, that was my plan. And I hear, Marcy. So I went across by the secretary's desk, and I go into her office and say, yes. She goes, we don't talk like that. And I said, well, I think we should. She said, no, take it out. And so I went and took out all the strong verbiage and left just the facts. And she was very happy with that. But I learned a really good lesson where you can really, really disagree with someone, but you don't have to be disagreeable. And that's an amazing skill that someone gets early in their career.
I have to ask, because after Justice Scalia said that one of her opinions cannot be taken seriously, she famously said, sticks and stones may break my bones. That's probably not true. Did she find Justice Scalia's barbs to be a little sharp?
She found them annoying and really capable of being ignored. She's one of these people that understood that if you do not give back to the person that's trying to taunt you, you can really drive them crazy. She was gifted at it. I mean, she told me one time that she had figured out dealing with difficult people. She had 4 levels of dealing with them, and you do this, and you try humor at this level, and you do this at this level. And I was like, oh my God, I should go get some notes, because I'm never going to remember this. She was just so good with people.
Excellent advice. Professor Sullivan, she famously made chili and had these Saturday sessions, and give us a sense of what it was like to have Justice O'Connor's chili and discuss cases at the same time.
Well, to give you a sense of how things worked, so when I was the 5th year in, these guys were a little earlier. So she came from the State Court of Appeals, so she didn't have a lot of experience either in federal law or constitutional law. And we were hearing, listen to me, wasn't confirmed. The court was hearing 150 cases a year, plenary. Now they hear about 75. So we were doing the cert pool memos. She wanted every case to have a bench brief. And we were doing the opinions, majorities, dissents, denials. So it was a punishing schedule, and maybe you remember the computer was only up till midnight, and 10 to 10 on weekends, and we were there every second that the computer was up. And so what we'd do is we'd write our bench memos, and then we were expected to read each other's bench memos for maybe 10 cases on Friday night. Does this ring a bell? And we'd get together on Saturday morning, and the justice would make her 3-alarm tacos or chili. I'm a girl from New Jersey. I did not know from tacos. I was just like, what is this? Anyway.
Was it really spicy?
It was good. I mean, once you got past the, foreignness for some people. Anyway.
Yeah, it wasn't the tacos that were hot.
Yeah.
It was the discussion.
Yeah.
So.
Well, all right. So I was usually in the hot seat. The justice, in my experience, tended to hire someone who was a liberal, a real conservative. And it didn't work every term like this, but I think it was somewhat intentional. And sort of two people in between. And I was clearly the liberal. And I shared my office with the conservative, with the real conservative. And we had a wonderful time because we both smoked and drank too much Diet Coke, and we had Hab. But anyway, so we got along famously, but I did get beaten up pretty thoroughly almost every Saturday. And I was only 27 years old, which was, I look back on it and I think, what were you thinking? You know, you had some nerve. So I was a little insecure and blah, blah, blah. But those sessions, she let us spar and didn't really enter into it until the end when she sort of gave you a sense of what she wanted. And she was really, really sincere about listening to a 27-year-old tell her about the cases. We viewed our role not as telling her how to decide them, but to make sure she could make the best decision possible. We were really honest about what the cases said. We were really honest about what the brief said. We might present our point of view, but our job was to protect her and to make sure she made the best decision, which included, of course, telling her how she had decided previous cases if she had.
That's fascinating.
Yeah.
That vision of her listening to the best arguments on both sides and deliberating and making up her mind is very powerful. Chancellor, can you take a particular case and give us an example of how that played out and take us into her decision-making process?
So I guess I'd take a case that I long after I clerked, which is Planned Parenthood v. Casey, which was, I just would say that she genuinely listened to everyone and she genuinely read everything. Mm-hmm. You had to give her everything you cited and everything you read that you chose not to cite, and marked with the pages that, these huge book cards you'd roll mm-hmm. in with when you were preparing both for argument and then later with an opinion. Planned Parenthood v. Casey I talked with her a lot about. That was 1992. And the clerks were very sharply divided, as maybe you'll hear later. And I guess I'd say she was able to, when she had to struggle between her belief in the rule of law and her intuitions from her own background and experience were the hardest cases from her, and I'd say that was about the hardest.
Professor Hamilton, we all want to hear about Casey, and that was obviously such a defining case for her. Can you shed any insights on that or other reproductive rights cases?
Well, I think I would compare to Casey the Hodgson case, which was our term, and it's the one case where Justice O'Connor would have voted to invalidate an abortion regulation. And the year I was clerking was one of those years when there was a very strong conservative cabal of law clerks that snuck around and thought they were deciding all the cases for the justices. And there was a lot of fighting over this case and a lot of unhappiness that Justice O'Connor was going to go the way of saying you couldn't say that two parents both have to give consent for a teenager to be able to get an abortion. But she was just a stalwart. She didn't really care what was going on in the halls. Mm-hmm. She did call me in one time and ask me about it. And I said, well, I'm going to be honest with you. I'm not being invited to these meetings. There aren't any women at these meetings. And she did not like that. So in the end, she just did what she wanted to do. And we agreed it was by far the best oral argument of the term. Absolutely fabulous oral argument, her kind of argument where the litigator for the Reproductive Rights Project was saying things like, well, the answer to that question is on page 152 in the second paragraph. Oh, and the answer to that one's on 845. And you could just see her going, check, check, you're right, okay. So it was an amazing year, but it is the only year that she's voted that way.
Wow. Professor Sullivan, there were two aspects of Casey that were so distinctive to Justice O'Connor. Her concern about the spousal notification provision, which she thought was a paternalistic violation of gender equality, and the undue burden test, which was so quintessentially central to her jurisprudence. Can you cast light either on those or on reproductive rights cases that you had during your term?
We did not have reproductive rights cases my term, and we also didn't have the unpleasantness because all our death cases were held for a case. And the death cases tend to bring out, when you're asked to stay in execution, it tends to bring out just the really visceral feelings of the clerks, and it can get really ugly. So our year was pretty benign. We had some reasonably important cases. We had an affirmative action case where she weighed in on whether affirmative action, whether strict scrutiny should apply when you're advantaging African Americans.
Tell us about that.
Well, that was very difficult, and she really struggled. But one thing about the justice, people talk about her discipline and her work ethic, but what people don't realize is how incredibly bright she was. I mean, you really don't, it always amazes me, and I think it's because her character was such, she made it look easy, but here she is, brand new, she's deciding these abortion cases a couple years in. We're wheeling in like 10-foot tall stacks of books, right? And she's doing that between exercise class at 8 a.m. And going out with John, dancing at 7. I mean, I really literally don't know how she did it. But it's in part because she was an incredibly quick study as well as a hard worker, and she was decisive. You know, she gave it her best shot and then did not look in the rearview mirror.
That decisiveness is so striking. She had a pillow at one point in her chambers that said, "Maybe in error, but never in doubt." And she heard the best arguments on both sides, but then made up her mind and didn't look back. And yet at the same time, she was such a model, she is such a model of thoughtful moderation, of balancing competing interests in the Madisonian spirit in a way that seems so rare and precious today. How can you reconcile those two features, the balancing moderation and the decisiveness? And if you can give us some specific examples, that would be great.
Well, first of all, she was a common law judge, and that's hard for people today to understand in a polarized era where people are playing to get their books, their cases in the textbooks. Rather, she wanted to decide things on the facts and the messy facts, and she'd seen as a politician, as a trial judge, she'd seen how messy the facts are. And then the second thing just to say is that she was often in doubt. She knew they were hard cases. Mm-hmm. So she wrestled really hard with them, but when she decided, she didn't look back because she had another case to deal with. And she really pushed me hard to say, the time to worry and the time to have doubts is before you make a decision, not afterwards, because if you wait till afterwards, then you're doing a disservice to the people in the next case. So she was capable of doing really hard things and moving on cheerfully and positively, which was not my nature or my upbringing. So it was a good lesson to me.
Common law judge, that's a resonant phrase. Professor Hamilton, what did it mean for Justice O'Connor to be a common law judge? What consideration moved her? Did she balance competing features? And again, give us specific examples.
So, you know, she was really an incrementalist in a lot of ways. And she was too humble to think that she could decide an issue for all time with one case. And she was very, very respectful of the case and controversy requirement. And so, and I really didn't come to truly appreciate that, honestly, until I started comparing her approach with her dear friend, Justice Scalia. And you know, for Justice Scalia, it was kind of Zeus handing the truth down from high. Right, and it was supposed to be the truth for the next 20 to 30 years, which has kind of turned into the court's way of operating. If they decide a case, they're just not going to take it for a very long time. She was much more willing to say, this is the four corners of this case. Here's how I would decide this case. And I am not going to pretend I know what's the next case. So in that way, I just found her to be just deeply fair and deeply concerned about the case in front of her, not the horizon and not, how she was going to go down in history. I think it's been unfair that she's sometimes been characterized as being the swing vote, or I've heard some characterize her as, looking both ways to see where the power was and then wanting to be the fifth vote. That couldn't be farther from the truth. She had a sense like a beacon. She knew where she wanted to land. She was going to land there. And if nobody else agreed with her on the court, well, then okay. But the way she operated, she often got agreement.
That's a fascinating observation, that she was the swing vote just by virtue of the fact that she happened to be in the center, but if it had been a different balance, she would have had the same approach.
Oh, and she would say later, over the years, that she had never changed, including when she'd gone to, in the courts of appeals, that the court itself had shifted right. And that it became increasingly hard to remember what it was really like to be a Republican and the right wing. She really no longer identified with that end of the political spectrum.
Many justices have said that in public interviews. Justice Stevens said he'd never changed, but the court shifted right, and Justice Ginsburg has also said that she did not change, but she thought the court shifted. And yet, Professor O'Sullivan, Justice O'Connor's unique common law constitutionalism was distinctively consistent. She was absolutely approaching cases in the same way at the beginning and the end, and it does seem so striking in its distinctiveness. There's not a single justice on the court who takes that approach today. So give us an insight into where that approach came from in her background and how it played out when you were clerking for her.
Yeah, her incrementalism and her distaste for footnotes. Don't even think about putting a footnote in an opinion.
Why not?
Well, I think she thought people were hiding stuff in there. I know she thought Justice Brennan was. She thought he put like Easter eggs in there so that 3 cases from now he could look back and say, oh yes, in a footnote we said X or Y.
And our year was the year that
He did that?
well, we were challenged to not have a footnote for the whole term.
Yeah.
And I think we made it. And it was for the reason you give. It was a fear that if she hadn't read it and didn't understand all its implications, she didn't want it there. And
Well, as to where her incrementalism comes from, I think part of it is just her personality. But part of it also was her deep experience. She had experienced legislature, she had experienced 2 levels of courts of appeal, 2 levels of judging. So she understood that the world is a messy place, right? These issues are not black and white, right? Justice Scalia could hold forth with this world-encompassing view, but she knew that actually the devil's in the details. And she also had a large measure of humility. When I interviewed with her, the one question she asked that I'll never forget was, she said, these cases are so hard. They come up and almost every single one, you could go either way. They're so difficult. And then she said, is there one case where you thought we really got it wrong, that is just unconscionable? And of course, I picked a case where she was in the majority.
Wow.
I wasn't prepared for the question.
What'd you pick?
I picked a proportionality case where a guy they said it was okay for a guy to get life in prison for 3 bounce checks. And I said, I understood that it's hard, different people make different judgments about sentences and it's hard to draw lines, but we may not be able to tell what's a just sentence, but we can definitely tell what's an unjust sentence. And again, my 27-year-old, there I am telling the justice what I think, I still can't believe she hired me. Honestly, I was really obnoxious. But insufferable, maybe. And that's one thing I really admire about her. She consistently hired people who disagreed with her and listened to us until, you always knew when the shutter came down. It came down pretty, but she listened to me for far longer than I would have. Certainly. And I look back on it and I think, God, what patience she had and what a commitment to good decision-making, because she definitely wanted to hear from contrary positions.
And what a powerful definition of judicial humility, the willingness
Right.
to listen to people who disagree with you.
Right.
Very memorable example. I think she spoke about how her background in Arizona politics led her to compromise, and she famously would have the Republicans and Democrats over to her house and make chili for them and listen to both sides. Do you think that that influenced her approach?
You know, there wasn't a lot of lobbying among the justices, and I guess I was earlier, but there wasn't. I didn't spend a lot of time with other clerks in other chambers, and I think she liked that. So there wasn't a lot of log rolling that we saw. Which I know you know, but unlike most institutions in Washington, the justices interacted it through written opinions circulated to the other justices. So it was the equivalent of an email message that everybody had to be copied on. And so I don't think that part of the legislative process is what translated to what I experienced. What I experienced was her just understanding that law is not a theoretical jurisprudence exercise. It comes out of a very challenging political process in which human beings that are not perfect try and figure out solutions. And so she was respectful of the Constitution and the balance between the states and the federal government, but she was very realistic that the individual actors in state legislatures, in the courts, among lawyers, were a mixed bag.
That pragmatism and understanding of the strengths and limitations of human beings and of institutions was widely praised, and some have argued that she showed the virtues of having people with political backgrounds on the bench. She was the only one during her service to have actually held elective office. Marcy, do you agree or disagree?
Oh, I completely agree that the fact that she'd held elected office and had been in a state legislature led her to have respect for legislators that most of the other justices did not have. And you know, I would look at, I mean, the most important case of our term, although nobody in the building understood this at the time, was Employment Division versus Smith, which was the peyote religious liberty case.
Wow, which you've written about as a scholar.
Yeah,
What
yeah.
amazing.
Yeah.
Okay, so tell us the story.
Became an obsession,
Yeah.
one might say. But she, you know, she would have decided that case by saying, okay, you're right. I'm going to adopt strict scrutiny under the Free Exercise Clause. But hey, Oregon, I agree with you that if a drug counselor uses illegal drugs, even if it's in a religious service, they don't get out from under the criminal law that forbids the use of illegal drugs. And so she had this like common sense approach that lawmakers were to be respected for understanding the need to be practical and pragmatic, and she had no time for the idealists. And so, you know, nobody really gave
I think
much.
the word was egghead.
Egghead, right? Well, yeah. I mean, when I told her that I was going into teaching,
Same.
when I told her I was going into teaching, she immediately called the U.S. Attorney of Philadelphia and said, Marcy's making a mistake, and you should call her and hire her right now.
Wow.
It's like, how are the maternity benefits there? And I had to go to the interview. There was no not going to that interview. She said, you're going to the interview and you're going to give both concepts an idea, you know, fair weight. I'm like, well, I did sign a contract with Cardozo Law School, but, and I went, and then I had to explain to her why I was still going into teaching. And the only explanation she accepted, so I said, Justice O'Connor, I'm 30. I got to have my children. She goes, okay. Well, and then she said, but maybe just put it all off. You know, just take a few years, have your kids. And I thought my husband was going to kill her. I said, no, she's just been gone for a year. Get to work. So,
She did think some of us should be academics. She just had very strong, she thought I should be a partner in a law firm. Viet Din, who you'll hear from later, came into academia and she had a fit. She thought he should be an investment banker. I mean, you know what? She wasn't wrong about a lot of these things.
You should have listened.
Yeah, I should have.
Well, that advice to take a few years and have kids and come back, of course, was her path. And then she came back and became the most trailblazing judge in American history as the first woman on the court. But during the time that all of you were there, she was the only woman on the court. It's remarkable to remember, but Justice Ginsburg didn't, of course, get there until 93. Right. What was it like for you to clerk for someone who was the only woman on the court, and did those dynamics ever arise among her?
Well, it is funny, everybody knew her name. Like if you said you were, most of the general public cannot name the justices. Now RBG they can name, but everybody knew Justice O'Connor. I was terrified. I mean, I walked in and I just was so scared. It didn't feel like she was the only woman because she's such a normal person. I didn't, it's not that you don't think of her as a woman. She wore a lot of perfume and lots of suits and, short skirts and stuff, but it didn't feel, maybe because she was comfortable. I was 5 years in, but she was a woman who really could talk to men. Men were very comfortable with her. Justice Powell loved her. He'd wander in his hush puppies and say, "Does Sandra have a little time for me?" That was the only schmoozing that went on. But she was completely comfortable in a man's world, and it never felt to me like, oh, she's a woman. She just got down to it. She worked as hard or harder than all of them. She was smart or smarter than all of them, and she got her stuff done. What was amazing about her was how disciplined she was and what a clear vision she had for what would make her happy, right? There was always an exercise component. There was a day of very hard work, hopefully with clerks that she liked, because she really did mentor us. And then she went out. She and John seemed to have a wonderful time, I have to say. I mean, they seemed to go out in Washington. We were reading about her in the paper all the time. Remember John Riggins? When he said, "Loosen up, Sandy baby"?
So,
yeah, well, he sent her a dozen roses with a little, "Sorry, love Riggo," that was up in the office. The justice also had a very funny sense of humor.
Yeah, I took those roses home to my wife.
Did you?
Yes, I would just tell you, so I was a man who worked for her, and my wife worked at NIH at a demanding job, and we had our first child in the middle of the clerkship, and it was a real blessing to work for somebody who understood that, because she was demanding, but she virtually adopted our kid. And she went to his college graduation. I mean, so she was somebody who understood two people in a marriage, both having professional lives and careers and needing to not lower the standards of what she expected of either one of them, but that the job of a boss was to be aware of both of them and their whole unusual family situation. I think that's why she hired all kinds of people. She was the first justice to hire people with disabilities. Yeah. She really hired a diverse array of clerks, not just ideologically, more clerks of color than almost anyone. And I think it's because of her background as understanding all kinds of people had something to contribute.
But she was also very generous. So I had a child and I wasn't married. This was 21 years ago. So, in our circles, it was not very common. And you can believe that the justice was the last person I called. And her response was, "Oh, good. You've got to have more than one because you'll just spoil them." And then I was so Christmas arrives and there's a knock on the door and there's the justice and Mr. O'Connor all dressed up with a Christmas present for Danny. And then she called him her grand clerk for years and was incredibly, incredibly generous. I mean, that's why her clerks tend to be enormously loyal, because she did work us pretty hard, but she was also just enormously gracious as a person.
She was very mothering. I mean, I've always referred to...
Did you get set up? She set up people on blind dates.
No. I've always called her my law mom. Because in my professional career, I was so blessed to clerk for Judge Edward Becker, who is the mensch of the universe, and then I got to clerk for my law mom, and she just was very caring in a way that you weren't going to see in other chambers. I mean, not your career path she'd already set out for you, which I kind of appreciated.
Until you deviated.
Until you, yeah. But she was also great at saying, yes, you must exercise and you must go do other things. I mean, she taught us that being a lawyer is not sitting in a dark corner 24/7. So when I interviewed with one of the big New York law firms after clerking for her in a moment of, oh, maybe I did make the wrong decision going to Cardozo, I talked to someone who's associate who said he had never seen his young children who were beautifully pictured there in the daylight.
Oh my God.
And I thought, you know, Justice O'Connor would not permit that. You would have seen your kid in the daylight. And that's just who she was. She had family values. She believed in fun. She believed in making us do things when we were too tired to do them, and we always ended up appreciating it. She fed us on the weekends. I mean, I don't think there's any other clerkship like it.
Wow. Well, in the spirit of Justice O'Connor, we must end this segment on time. We'll reconvene in a moment, but for helping us appreciate the judicious humanity of Justice O'Connor, please thank our panelists.
Thank you.